Yes.
My Lords, I and my learned junior, Thompson Quinton, appear for the claimant, who are the appellants in this matter, EasyGroup, Easylive, and my learned friend Christopher Akins appears for all three of the defendants and the respondents. The first defendant is the corporate one, and D1, the D2, D3 are directors. As you well know, this is the first of two appeals that have been listed to be heard back.
Yeah.
In the second case, which is starting tomorrow and runs into Thursday, there's slightly different representation. On my side, so to speak, my learned junior will be the constant element, but he will be led then by Simon Malinich KC. And on the other side, my learned friend will be the constant element, and he will be led by Miss Emma Himsworth KC. So it's just so you know broadly who's going to be acting for whom.
Yes. And have you had a discussion about the timetables?
Sorry, with respect to...
Well, the two appeals.
Yes, today, my lord, is for 1 day. Tomorrow is for a day and a half.
Yes.
And with respect to our timetable for today, yes, we've had a discussion as to how we're going to deal with the various matters, right. The appeals, cross appeals. I was going to come to that in a moment.
I mean, the court's position is we're relatively relaxed, but we must finish by lunchtime on Thursday.
Yes. We were indicated that we had a day.
Yeah, but I mean, if you ran into tomorrow morning a little, that wouldn't inconvenience us, provided that there was some give on the other appeal. The point.
Yes, my lord.
The fixed point, as far as we're concerned, is
Thursday.
Is Thursday lunchtime.
My lord.
So we've read the papers. We have an appreciation of the issues. I hope that's of some help. But you'll doubtless take your own course in terms of what you emphasise.
My lord, yes. You'll have seen the authorities bundle is quite large, but that's because it encompasses all of the authorities for both appeals. So it's not just 40 authorities for this appeal. You're not going to get another authorities bundle tomorrow, so to speak.
Well, if we were, it might go back with a flea in the ear.
Yes, well, exactly. But I just wanted to make that point.
Frankly, I had made that assumption.
Right. My lords, this is an appeal from the judgment of Mr. Nicholas Caddick KC, sitting as a deputy from September last year. There is a notice of appeal that has 4 grounds. There's a respondent's notice that has 2 parts to it. The first of which is that there's a cross appeal which basically has 2 grounds. And there's also a notice of different and additional reasons that has 3 grounds. Pursuant to the announcement in November 2023 of Lady Chief Justice Baroness Carr, subject to your lordships, my learned junior was going to address you on one of the different and additional reasons.
Excellent. We've
carved it up in this way because that makes some logistical sense, but again, it's subject to your approval.
No, we approve of that whole regime. It's a very good idea.
To answer in more detail with respect to the running order of today, I was going to open, obviously, on the appellant's grounds for appeal. I've indicated there's 4 of them. One is incredibly quick because it's basically consequential upon the other 3. But I was also going to touch lightly upon the second of the different and additional reasons because it dovetails in with one of the grounds and makes logical sense to deal with there. Then my learned friend will obviously answer my appeal, and he will open his cross appeal and different and additional grounds. I will then reply and answer to the cross appeal and additional grounds, and my learned junior at that stage will address your lordships on the first additional and different grounds. And then my learned friend, this is the 4th time, so to speak, of the tennis match, he will stand and reply on his cross appeal and his additional and different grounds. So there's one other point by way of housekeeping. You'll have noticed that obviously this is there's a transcript being made, and I've been asked to ask your lordships whether it might be possible we have a break halfway through the morning and afternoon.
Yes.
That will probably work quite well in the morning because I hope to finish after about an hour and a half. And so when we, so to speak, change roles, that might be a suitable time to rise for a moment or two to give the transcribers a
Fine.
rest.
Yep, that will be fine.
Fine. So, by way of very brief introduction, you'll be aware, of course, that the matter at first instance was a trademark trial, which was basically a dispute between trademarks that contained the word Easylive against signs that basically contained the word Easylive. There's also an issue of trademark invalidity that arises. If I just take you to the amended particulars of claim, so as to put the various matters in slightly more context, you'll find that in the core bundle, tab 18. You're all working from paper copies, but I'll give page numbers for the transcripts as well. Starting at page 138. And if we turn the page to 139, paragraphs 3 and 4 are the two relevant marks upon which the appellant relies. Paragraph 3, you can see an Easylive stylized mark, that's the 695 mark. And then in paragraph 4, you can see the Easylive word mark, which is the 904 mark. And then if you turn to page 143, paragraph 9, you'll see that the signs that are alleged to have infringed are identified. They fall into 4 groups as identified by 9A, B, C, and D. Then if you turn the page, now on page 144, paragraph 11, you can see that there's a defendant's mark, which is the 957 mark, Easylive auction. It's a series of 2, 3 separate words and 1 word running together. Paragraph 18 indicates the cause of action, which is just the Trademarks Act, section 10, subsection 2B, which is, and I'll deal with this in slightly more detail in a moment, but broadly, it's the case where you need to have identical or similar marks and signs, identical or similar goods or services, plus the existence of the likelihood of confusion. But the reason why I'm taking you here is that that's the only cause of action. There's no separate cause of action under section 10.3, and there's no claim under passing off, the common law tort of passing off. In passing, you can see on page 146, there's an allegation of joint tort feasorship. Nothing turns on that because for the purposes of this case, joint tort feasorship was conceded. So you can park that. And then the last thing that's relevant in the amended particulars of claim may be found on page 147 of the bundle at paragraph 22. This is an allegation that the defendant's mark, the 957 mark, is invalid, in essence by reason of there being a conflict between it and the earlier rights that form the basis of the infringement claim. And then, again, very briefly, if we go to the re-amended defence and counterclaim, which you'll find behind tab 19, starts at page 152. But for the purposes of this appeal, what's critical is the counterclaim, and you'll find that commencing on page 161. And at paragraph 33, you can see that there's an allegation that the stylized mark 695 ought to be revoked on the grounds of non-use. That's the earlier mark, stylized mark, and because it's been registered for more than 5 years, if it hasn't been put to genuine use, you can revoke it. But then if you turn the page, 162 of the bundle, and paragraph 35 of the re-amended defence and counterclaim, you can see that there's a different attack upon the 904 mark, that's the new mark, and that attack is predicated upon it being invalid. A number of reasons, but one of which would have been the defendant's intervening mark. Now, in the judgment, which you'll find in the same bundle, the core bundle, at tab 11, again very briefly because I'll have to deal with this in more detail later, what was found was that the use that had been made of the earlier stylized mark, the 695 mark, was not used as registered, that was admitted, but the variants that were proffered up as amounting to genuine use were held to be acceptable variants under section 46 subsection 2 of the Trademarks Act, and therefore use of those acceptable variants was sufficient to maintain prima facie the registration. The long and short of the next stage is whether or not the specification should be narrowed down, was that it was narrowed down with respect to those services for which it was admitted there was no use, but beyond that there was no narrowing. But the next most important thing is that there was found to be no infringement under section 10(2)(b), and therefore the attack on the validity of the defendant's trademark 957 failed, and so it was also then unnecessary for the invalidity attack upon the later of the claimant's marks, the 904 mark. That did not need to be considered. The defendants, the respondents before you, then got 90% of their costs. That's appealed, but in essence it's cascades upon what you decide. So there's not a separate, what I'm trying to say, it's not a separate cost appeal regardless how
It's
you...
parasitic.
Exactly so. Now, the grounds of appeal deal with 4 matters, the first 3 of which relate to the finding that there was no infringement. And this is divided into 3, the first of which was that we need to attack the finding that there was no conceptual similarity. Again, I'll flesh this out in more detail in a moment. There's an issue with respect to the effect of enhanced distinctive character of the trademark. And then thirdly, whether or not in any event there existed a likelihood of confusion such as to complete the tort under section 10(2)(b). The 4th ground is the invalidity of the respondent's 957 mark, and that is completely, again, parasitic upon the previous findings. That's agreed, basically, but it needs to be there as a grounds of appeal. The cross appeal deals, of course, with the defendant's respondent's counterclaim, and in particular with respect to whether or not the variants that were used, that were held to support genuine use, were acceptable variants. And the second point is, even if they were acceptable variants, whether or not there should have been, in any event, some narrowing of the specification. And there's a formal appeal on the cost, but that, again, is parasitic. And then, with respect to the respondent's notice, but this time with respect to the different and additional reasons part, there were 3 parts. The first of which is that in any event, there should be a reassessment of the finding with respect to the comparison of the services in consideration. There's an issue with respect to distinctive character, and I was going to deal with that because it's in essence closely related to one of my grounds of appeal. And then the third point that arose was that the invalidity attack on the 904 mark should have been successful. But that now has been dropped, and so therefore that simplifies the matter. Now, with that by way of lightning introduction, I was going to go into it in a little bit more detail. My lords, you will have seen from the authorities bundle, you probably don't need to go to this, I can just read it out. The authorities bundle, the first one, and behind tab 1 sets out the Trademarks Act, and the relevant provision with respect to infringement is section 10, and that's found on page 7 of the bundle. And we're looking at, in particular, 10.2b, which says the person infringes a registered trademark if he uses in the course of trade a sign where, because the sign is similar to the trademark and is used in relation to goods or services identical with or similar to those for which the trademark is registered, there exists a likelihood of confusion on the part of the public, which includes the likelihood of association with the trademark. So the core of that is you need identicality or similarity of the mark and sign, identicality or similarity with respect to the services, plus the existence of the likelihood of confusion. And that then completes that tort. Now, unsurprisingly, there's been some judicial comment on that, but conveniently for me, certainly, is that it's all been summarised in a case called Liverpool Gin, and you'll find that in the authorities bundle, second authorities bundle, and it's the last tab there, tab 21, and it's on page 711 commences. And the law on the likelihood of confusion is set out between paragraphs 7 and 14, and that commences on page 716. Now, the way in which this is done is that in paragraph 8, the law has been set out with respect to the very similar provisions with respect to whether or not there's a conflict at the opposition stage, but those marry over directly to what is relevant with respect to infringement, and that's expressly stated in paragraph 9. But retaining our focus upon paragraph 8, there are 4 sub-paragraphs that are particularly pertinent for this appeal, and that is 8D. But when you're trying to assess whether or not there's a conflict, it's important to look at the visual, oral, and conceptual similarities of the marks. Must normally be assessed by reference to the overall impressions created by the marks, bearing in mind their distinctive and dominant components. But it is only when all other components of a complex mark are negligible that it is permissible to make the comparison solely on the basis of the dominant elements. That turns up in particular with respect to whether or not the variants that are being used are acceptable. And then if you go to 8E, nevertheless, the overall impression conveyed by the public by a composite mark may in certain circumstances be dominated by one or more of its components. That dovetails in with the previous subparagraph. And then G, a lesser degree of similarity between the goods or services may be offset by a greater degree of similarity between the marks and vice versa. So this is where basically if something is incredibly similar with respect to the marks and signs, but less so with respect to the goods and services, there could still be a conflict. And the flip argument is also true. And then H, there is a greater likelihood of confusion where the earlier mark has a highly distinctive character, either per se or because of the use that has been made of it. So what that says is that if you have an enhanced distinctive character, then it is more likely that there will be a conflict. So the rights of a highly distinctive mark are greater than those of a mark that has not been used. Now, in this case, there's manifest similarities with respect to the signs and the trademarks. Clearly, that's true with respect to visually. Easylife is visually quite similar to Easylive. The same holds true orally. There's clearly a great degree of similarity there.
Well, can I ask you this question? You've adopted the pronunciation Easylive for the defendant signs. And do you accept that that's true of all of the defendant signs?
No. I was going to deal with that in more detail later, but
Right.
no is the short answer to that question now.
Okay, well, let's deal with that in due course.
But in this case, the battleground is fought on conceptual similarity or not. With respect to the identicality or high similarity of the services, in essence, this was found to be the case with respect to all the relevant services. And if I may take you to the judgment, you can see this is the case. The judgments in the core bundle behind tab 11. And if you go to page 99 of the bundle, paragraph 58 of the judgment, this is a useful paragraph because what the judge has done is he set out the relevant services, the class 35 services and the class 39 services, but in particular, he has introduced some breaking up of the class 35 services. And you can see that by the underlined text and the parenthetical comment at the end. The reason why this is useful is because the 35A services, so to speak, are the advertising and promotion services. And then he breaks up the rest of that long paragraph into 4 distinct parts, B little Roman 1 to B little Roman 4. And if you turn the page to page 100 of the bundle and paragraph 62 of the judgment, this indicates that with respect to certain of the services, namely B little Roman 1, B little Roman 4, and the class 39 services, there was no use. So those fall away basically straight away. But then with respect to the remaining services, he finds at paragraph 94, which is on page 107, that the advertising services are identical to those services in which the defendant is engaged. And then if you turn the page to page 108 of the bundle, this time paragraph 100, with respect to those other services, so that's B little Roman 1, B little Roman 4. What have I got that wrong way around? I think it's 2 and 3, sorry, yes, exactly. He says that those are either identical or highly similar. Now, it's important to note at this stage that the statutory test is for there to be an existence of the likelihood of confusion. You don't need to show that there is actual confusion. And in this case also, the allegation of conflict is predicated upon an allegation that there is direct confusion, i.e. that a relevant member of the public would mistake Easylive for Easylife. That then brings me to the first ground of appeal, which addresses the issue of conceptual similarity. Now, staying within the judgment, going back to paragraph 86, which you'll find on page 105, the judge here found that between Easylife and Easylive, conceptually, he said they were very different. And his justification is that Easylife stands by itself, but Easylive does not. You need something else.
Now, I observed that the judge deals with all the defendants' signs together and doesn't differentiate between them. I'm assuming that's attributable to the way the case was argued before.
Well, there's a slight nuance to that, Lord, in that he does actually differentiate slightly between those signs that are just two component parts, Easylive, and also those that have the word auction afterwards.
Yes, at the end of the paragraph.
Yes, exactly.
Yes.
And also must also be services as well, because that did form one of the grouping that I showed you in paragraph 9 of the amended particulars of claim. That goes.
Does he address that one?
Not, shall we say, quite so expressly. You can draw your own conclusions from that. I mean, but services, the company name has services in it, my lords. So it's Easylive Services Limited. Some of the signs are Easylive and some of them are Easylive Auction.
I might think that there's room for conceptual difference there.
My lords, yes, or my lord in this particular, yes, but I was going to deal with that now, if I may.
All right.
So, because there's a number of points that need to be unravelled on that.
All right, but what I need to be clear about
Yes.
is what your case is. Mr. Akins can tell us what defendant's case is in due course. Is it your case that we have to consider each sign individually and that there is scope for different conclusions in relation to the different signs, or do you say that the same conclusion applies to all?
The first proposition that you put towards me. And that will become clear when I go through why I say the judge made some mistakes, because there is a differential in the reasoning with respect to the seriousness of his error. So with respect to the first point, namely that Easylife stands by itself and Easylive not so, we say that that's not right just as a matter of general principle. He seems to be saying that Easylife does not stand by itself because in essence it should be treated as an adjective. And so therefore it needs a noun to qualify it in order to give it some meaning. But I would say that's wrong, because I would say that an adjective still can have a self-standing concept. One is not talking here grammatically about what one is forming, but concepts. It's perfectly possible for the adjective big to have a freestanding concept, even though, of course, you normally use it in respect of a noun, big table, big house. But that doesn't deny the fact that the adjective big has a self-standing concept. So we say that was an error in his analysis in the way in which he tried to differentiate conceptually between Easylive and Easylive. Now, the next point is, you'll see if you read 86 in detail, that with respect to, this follows on from his first point, that you need something to qualify or to give context to the Easylive. And the way in which he said that worked with respect to those signs that contain the word auction, so you get Easylive auction, is that the auction then gives meaning, so to speak, to the Easylive. But, and this is where we say he also fell into error, he did that analysis also for the simpler mark, Easylive by itself. Now we say that's an error because when you're looking and considering the comparison between a mark and a sign, you should look at the sign in essence independent of those goods or services in relation to which it has been used. So you have to look at it discreetly. And therefore, when you are looking at the conflict or the alleged conflict between Easylive and Easylive without the word auction, it is impermissible, we say, to take into consideration the fact that Easylive is used in respect of auction services. Now, my support for that proposition comes from a case that may be found in the second authorities bundle at tab 19, commencing at page 678. And this is the equivalentia case. And the relevant passage for present purposes may be found at paragraphs 72 to 73, which commence at page 688. However, as the EUIPO, to put this in context, this is an appeal to the, actually to the Court of Justice, but it's come all the way through from the European Intellectual Property Office, which deals with European trademarks. And so the EUIPO stands for the European Union Intellectual Property Office. So paragraph 72, however, as the EUIPO rightly argues, taking into account the circumstances in which the goods or services covered by the two signs at issue are marketed for the purposes of comparing those signs could lead to the absurd result that the same signs could be classified as similar or different depending on the goods and services they cover and the circumstances in which they are marketed. 73. It follows from the foregoing that the General Court erred in law by taking into account in paragraphs 48 to 53 and 55 of the judgment under appeal of the circumstances in which the goods in question were marketed at the stage of an assessment of the similarity of the signs at issue as a whole, and by giving precedence by reason of those circumstances to the visual similarities between those signs over their phonetic similarity. So the point,
while we're on this authority, it's convenient just to pick up at 74, following they address the issue of conceptual counteraction. Am I right in understanding that conceptual counteraction is not relied on in this case? I appreciate that's not really a question for you, but
yes.
It doesn't seem to feature anywhere that I've noticed.
Well, those words are not used. I say that it can't be relied upon in this case but it seems to be a sotto voce reason for saying that there is a conceptual similarity.
Not a similarity.
There is
I mean,
not.
as you appreciate, the reason I asked the question is that, as the Court of Justice makes very clear, conceptual counteraction is quite a stringent test.
Yes, I was going to deal with that. You can see by my markups on paragraph 74 in a moment. But shall I deal with that in more fully when I was going to, or
By all means.
yeah, right? But you will need to go back to 74. But finishing off from what I was going to say on paragraph 72 and 73. At this stage of the analysis, when you're comparing this mark, the trademark, with the allegedly conflicting sign, you do that without reference to the goods or services in relation to which that sign might have been used, because as otherwise indicated by the Court of Justice, you could lead to different results when those goods and services are different. So here, the error committed by the judge is that with respect to the Easylive mark, he still took into account the auction services in order to justify his conclusion that there's a conceptual dissimilarity. We say that's wrong with respect to those marks, and that would also follow with respect to the Easylive services mark, which is the company name.
Where did you do this exactly in this paragraph? Where's the error in that?
If you're looking at the judgment at 86, it's towards the end. I don't know where your hole punches are, but
It needs something more, and
Yes.
it begs the question, an Easylive what?
and then it carries on
Yeah.
with respect to the auction part.
It's the last sentence you're objecting to here. In the other cases, the question is likely to be answered by the context in which the sign is used, which in this case is likely to make it clear it's a live auction.
Yes, my lord.
So that sentence is the error
That-
you're
that-
pinpointing at the moment.
Yes, that's the actual error with respect to the Easylive, but the way in which he sort of founded that error, we say, was through the first part. And so, my Lord Justice Arnold, that brings me back to a point that you raised earlier. Am I drawing distinction between the various allegedly conflicting signs? The answer is yes, and that's basically the reason why. Because when you have a sign that has Easylive auction, that in of itself gives you some indication, some colouring with respect to the Easylive bit. But with respect to Easylive and Easylive services type allegedly conflicting signs, you can't import any conceptual understanding of auctions, because to do so can only be done by reference to the services in relation to which those signs are used, and that's impermissible in my submission. And therefore, to take your point to its logical conclusion, it is possible to reach different final outcomes.
So the next question is, what's your position in relation to the Easylive auction signs?
Well, that's our fundamental point, that there is still a conceptual similarity. The auction part of that sign is not sufficient to introduce a conceptual dissimilarity lever. And that was going to bring me, so to speak, to my next point, which is I say that if you look at the words life and live, and we set this all out in our paragraph 13 in our skeleton, which for your note is found behind tab 6 on page 36, that those words, commonly in the dictionary, are defined often by reference to each other. I use that as, so to speak, an argument. There is some close linkage between those words and the way in which their general concepts are similar. My lords, I was then going to actually pick up, if I may, upon the point that my Lord Justice Arnold has just made with respect to paragraph 74 of the judgment to which I was taking you behind tab 19. And this is the point with respect to the principle of conceptual dissimilarity acting as a sufficient lever to overcome all other similarities, so that in the final analysis there does not exist a likelihood of confusion. And the point here is that this may operate, but what it requires is, and you can see this in about line 5, provided that at least one of those signs has, from the point of view of the relevant public, a clear and specific meaning, so that the public is capable of grasping it immediately. There's a number of points to unwrap here. First of which is it suggests that there has to be one as opposed to a multitude of clear specific meanings. And in this context, it's worth noting that in paragraph 61 of the Respondents' skeleton, which you'll note is behind tab 8, page 62, it suggests that it is only arguably does Easylive have a clear meaning. Now, obviously, I don't hold that as an admission, but it does seem to suggest that it supports the proposition that I'm going to make, which is that Easylive conveys a number of imprecise concepts. So, for example, that no hardships have been encountered, or if hardships have been encountered, then one has the means to overcome those difficulties. Or maybe it relates to the fact that one's had a privileged upbringing, the classic silver spoon in the mouth type sentiment. Or maybe it refers to good health, or a stable home life, or a more general safe environment. So in my submission, there's no single clear and specific meaning that is capable of being grasped immediately, and therefore this principle that conceptual dissimilarity can act to undo any other similarities is not applicable.
The question I was really asking earlier, and my question was imprecise, so it's my fault, which is, to what extent are we concerned with this as an issue in the case? Because at the moment, it doesn't seem to me the judge has relied upon the principle of conceptual counteraction. He doesn't use the phrase. Correct. He doesn't cite any of the relevant case law.
Correct.
Not totally clear to me that it's therefore an issue, because there's no respondent's notice raising conceptual counteraction, is there?
The way in which it arises, as I said earlier, is sort of sotto voce, in the sense that...
Well, you can't do that.
Well, no, in the judge's reasoning, is that because he seems to be hanging everything upon the conceptual dissimilarity to undo what we say are prima facie similarities and or identicalities when he reaches his final conclusion. So he must have given great weight to his finding of conceptual dissimilarity. So even though he hasn't relied upon the cases expressly, this must be in the way in which he reached that final conclusion.
Well, is that right though? Well, I'm just trying to remind myself of what his overall conclusion is on
Yes, just 1 second.
similarity. It's 105 and 106.
Yes. What? Sorry, my lord.
Are you submitting that that's effectively conceptual counteraction?
Well, my lord, if you go to 106, and he's talking about conceptually quite different. His finding, the judge's finding, that there does not exist the likelihood of confusion is predicated upon the fact there's conceptual dissimilarity. And I'm saying this is not a case where, even if there is some conceptual dissimilarity, which I disagree with, it is one where it could fall within the principles where conceptual dissimilarity can trump everything else. So it's by way of a safety net.
In paragraph 74, the question is whether at least one of the signs has a clear and specific meaning. So it depends. Does it not depend which sign you're comparing it with on the defendant's side?
Yes, the way in which that's normally understood is that they're using the word signs there to encompass both the trademark and the allegedly conflicting sign, and if one of them has a clear meaning,
Yes.
then that can be used.
Yes. So what about the I can see why in relation to the sign Easylive or Easylive, there's no obvious conceptual specific meaning. What about Easylive auction? Do you have to consider that as well? If that does have a specific meaning, doesn't that take you outside this point?
Well, that might be another reason why there might be a difference in the findings that you reach with respect to, yes. But I would still say that that's still not clear enough. It might be less unclear, but not clear enough to fall within the ambit of this. That's how I'd address that point.
And a broader question, what's the difference between taking into account the extent to which there are phonetic and visual similarities or differences, and the extent to which there are conceptual differences, on the one hand, reaching an overall conclusion. On the other hand, saying, well, we're using here, what's the phrase, conceptual counteraction. What's the difference between one's a ground-up approach, one is saying, I think, well, there are similarities, but they are counteracted by the conceptual differences. Which has the judge done here?
Well, what we say is that the judges use the conceptual dissimilarity to trump everything else, and we say that's impermissible.
Unless there's conceptual counteraction.
Yes.
Because the whole point about conceptual counteraction is the hypothesis is that the visual and oral similarities are sufficient to create a likelihood of confusion, but that's, as you put it, trumped by conceptual difference. And you say that's impermissible except when you've got conceptual counteraction as conceived by the Court of Justice, which requires at least one of them to have a clear and specific meaning.
Yes.
The paradigm case being Picaro versus Picasso, and everybody knew that Picasso was the name of the painter.
Yes. One of the few surnames that has such a unique, focused meaning that can be readily grasped immediately. My lord, does that?
Well, I think your submission is that the judge has in fact used conceptual differences to trump everything else.
Yes.
He doesn't say so.
Well, he's found that orally they're similar, visually they're similar. He's found identicality or high similarity with respect to the goods and services.
Yes,
So-
but we're focusing on the sign, I think, similarity. of the
Yes,
signs.
but the point about the trumping is it is a trump card that trumps absolutely everything else. All the other direction. Sorry, it trumps the fact that all the other indicators point towards the existence of the likelihood of confusion.
Yeah, but
It's
he doesn't make that finding that everything else points towards the likelihood of
No,
confusion.
but his reasoning is that everything else points towards it. My lords, I was then actually going to pick up on a point my lord Zacaroli's just made, and with respect to one that my Lord Justice Arnold has made, with respect to the pronunciation of the allegedly conflicting mark. So is it easy live or is it easy live, as in to live easily? Now, this is not a point that is really developed in the judgment, but it is developed slightly in the skeleton argument of my learned friend at paragraph 59, which you'll note is tab 8, page 62. He says that such a pronunciation, in essence, which gives a verbal meaning to the second part, would not make sense grammatically, but that in some senses is completely irrelevant, because if easy live is the way in which it is pronounced, then that would give it some spark of distinctiveness and therefore would remove it from or diminish the descriptive nature of that mark, that sign.
It's quite hard to note this submission
Yes,
in writing.
you have
I'm
to
comparing
use...
easy live with easy live.
Yes,
Give.
yeah.
Short I or long I.
Yeah.
Yes, if you look in the...
use the phonetic.
I'm comparing living and concert. How about
my lord, for your note, you'll find actually in our paragraph 13, where I quote from the dictionary, it has the phonetic spelling, so to speak, which might help, but it might not. But that's as far as I can go, my lord.
Only if you're familiar with phonetic symbols.
Yes, well, exactly. That's why I put in that qualification, because I had to think about it myself a bit. So, with respect to all of those points, bringing them all together, we say the finding that there is conceptual dissimilarity is unsupportable. We say actually there should be a finding of conceptual similarity. And once you do that, then that feeds into the overall analysis of the existence of the likelihood of confusion. My lords, I was then going to deal with my second ground of appeal, which is quite short. And that is the point with respect to enhanced distinctive character. And if you go to the judgment, paragraph 108, page 110, this is where we say the judge erred on a separate point. He said, I accept that this establishes an enhanced distinctive character for the Easylive stylized mark. However, I agree with the point made by Mr. Aikins in opening that this does not mean that the average consumer was any more likely to be confused. We say that's wrong. As I showed you in the London Gin case, at paragraph 18, subparagraph H, if you have an enhanced distinctive character, then that does feed into the analysis in my favour because it makes the existence of the likelihood of confusion more likely. The way in which this is rebutted is that it's put forward that this is only a general proposition that doesn't always apply. And my rebuttal to that is to say that when the case law is analysed, you can see that it's always been said in general terms. There's no qualifications or caveats. It's of general applicability, and the summary that was given in paragraph 88H didn't have any qualifications or anything like that. The next point, and this is dealing very briefly with what is raised in the second point on the different or additional reasons, is that even if you have an enhanced distinctive character for particular goods and services that are being used, that does not encompass all of the goods and services that might be included within the registration. And the way I would deal with that is by saying that if you have an enhanced distinctive character that has been acquired through use upon certain goods and services, then there's going to be a penumbra of perception by the public that will be outside the bounds of actual use and will seep into the wider goods and services that are covered within the specification.
If the judge in 108 had said this does not mean that the average consumer, or there was any material increase in likelihood of confusion, there would be no complaint, presumably.
Well, there still might be, my lord, because the way in which the case law seems to develop is that it's a material point in every situation. That if there is the way in which you have to put it is, the more enhanced the distinctive character is, the more it affects. So if there was only a little bit of enhancement, then the effect might not be very material.
It's always a question of degrees.
Yes, but it's always in one direction. So you have a little bit of enhanced distinctive character and it increases the likelihood a little bit. But here, you've got a large enhanced distinctive character, therefore it should have a material effect.
Material in what sense? That it flips it from being a finding of no confusion into a finding of likelihood of confusion per se. Can't be right, can it? But it always flips the switch, as it were.
Well, the trouble is, my lord, what you're doing is you're looking at one point in a multifactorial analysis and saying, focusing just down on that. We say it augments the whole argument. There should have been a finding. But his error is by basically putting 0 to that lever. And that's wrong. When we get to your point, my lord, about the materiality of the effect and whether he had qualified his statement, in some sense I'm grateful that he didn't qualify it in that way, because I then don't have to try and argue that there would always be some flipping of the switch, as you've put it.
So you say there's two different questions. Question one is, did the judge err in his application of the test? You say he did because he discounted enhanced distinctive character having any effect on likelihood.
Yes, he assigned 0
Then
effect.
you say question two is, what is the proper conclusion upon a reconsideration?
Yes, and we say
And you accept that the fact the judge has made an error, even if you're right about that doesn't predetermine the outcome to question two.
that's right. But I could never say that.
No.
Because the way in which this works, as far as I can see, my lords, is that I have to say that there's an error, and that gives you the jurisdiction to consider the matter again. I then argue that when you consider it again, it is in my favour, but it can't. The answer to the first question cannot predetermine the answer to the second question, which is for your lordships to then decide.
But going back to your point about the breadth of the enhanced distinctive character in terms of goods and services, do you have enough authority to support your proposition that it extends outside the goods and services in relation to which there's been actual use?
No, my lord, but I would argue it on the basis that the whole point about an enhanced distinctive character is its effect upon the public's perception. And the public's perception would be, in my submission, that there is an enhanced distinctive character with respect to obviously those goods and services in relation to which there's been massive use. But it wouldn't necessarily be so narrowly and clinically delimited by that use. It would spread out, because that's the way in which people perceive things. They perceive things with a penumbra. They don't perceive things with hard lines either side of the precise use. An easy example would be, I use it only upon blue magnets. Perception would be probably upon all magnets. That's as far as I can take the point.
Well, isn't there two different questions? The first question is, what's the extent of the enhanced distinctive character? And then the question is, what impact that has upon likelihood of confusion? I mean, I can understand the argument that it doesn't matter when you get to assessment of likelihood of confusion. You're arguing that the judge made an error at stage one. I think.
Yes.
Or at any rate, you're rebutting a respondent's notice.
Yes.
That's raising that question.
Yes, I mean, some of this is a bit of shadow boxing, I'm afraid.
All right. Well, that's as far as we can take it for the moment.
Yeah. There's another small point that's raised in the skeleton against me, and that is that the judge in paragraph 138, rather unfortunately, with respect to the Easylive word mark, said that it acquired an enhanced distinctive character by reason of Easylive's extensive trading since September 2020. That can't be right, because any enhanced distinctive character acquired after September 2020 is irrelevant. I have two answers to that. The first of which is a weak one, which is that clearly must be a drafting error. He probably meant before. But the better answer is that as of September 2020, the Easylive word mark, because that's when that mark came into existence, immediately acquired an enhanced distinctive character by reason of all the use that had went beforehand, in particular with respect to the 695 stylized mark. So therefore we say in essence it was an error that the judge found that the effect of enhanced distinctive character did not have any bearing upon the question that was before him. We say when you correct that error, it feeds in the analysis in our favour. That brings me to the third ground, which is meeting head on the analysis of the existence of the likelihood of confusion. And this is where relevance of the TVIV case, which is maybe found in Authorities Bundle 5, behind tab 39, page 1458. And the relevant paragraphs for your note are paragraphs 78 to 81 in particular, which start at page 1478. The reason why this is pertinent is what happened here was that this case was relied upon by the judge at first instance. So the case before the judge at first instance was the TVIS case at first instance. And then it went to appeal, and matters were changed somewhat on appeal.
But in any relevant respect, because Mr. Caddick picked up the point that I made, that when you look at the European case, you don't find any explicit support for the concept of administrative error.
Yes, that was all pointed out.
But nevertheless, that was accepted both by him and by this court.
Yes, that was all pointed out.
So in terms of legal analysis, what difference does it make? Of course, the courts came to different views, but that was really for other reasons.
But it seems to be that even though the term administrative error was pointed out to him, because that was expressly pointed out to him with respect to that case of first instance, and that case relied upon the European case, both the first instance and on appeal, that term was never really used. The point here is that the examples have been dismissed as, in essence, administrative errors, and we say that's clearly wrong when you actually look at them. So, pick that up. If you go to the judgment,
well, can I be clear? Are you saying that they demonstrate that the reasoning, that there's the same fallacy in the reasoning as in TVIS? Because the key fallacy in the reasoning in TVIS was it was said there was a conceptual difference, and that was wrong, but that point was reinforced when one looked at the evidence of actual confusion, because what the evidence of actual confusion showed was that the supposed conceptual difference wasn't noticed by any of the consumers, and therefore that was not, it was further support for the proposition that the supposed conceptual difference was not negating a likelihood of confusion.
It's both those points here. We say that the first instance judgment in the case before you now clearly thought that there was a conceptual difference. We say there's not. And secondly, we say that the evidence that was put before him, that is the judge in this case at first instance, supports my point that these examples do not evince an argument that supports there is a conceptual difference. Rather, they show that there is no conceptual difference.
Okay.
So, going to the judgment, paragraph 117, which may be found on page 111 behind tab 11. The first point is just really, if you'll note, having been through these 87 examples, what you'll actually see in the supplementary bundle is 86 examples. One was by accident missed out, but as it's not a very interesting example, we haven't troubled to correct it. But
Well,
it's
in
case anybody does all the maths and starts working out, the numbers don't add up. That is true, they do not add up.
But there were 87 before the judge.
Yes, there was. You have 86. There's one more. It's not exciting. It just reiterates other points that have been made already. And it actually falls into the first group that he's considering, namely the 76. So you'll only find 75 of that sort of example. But what we have here is, in paragraph 117, we have examples when he's talking about the 76, 75 of defendants themselves, auction houses, or their customers referring to the defendants as Easylive, not Easylive. Now, the reason why in my submission you can't just dismiss all of this quite so readily is because if you take, for example, auction houses, there's examples here of auction houses who use the defendant's services, write into the defendants, and getting the name wrong. And so you would have thought that those people who are using the services themselves ought to know the name of the service provider, yet they're getting that wrong. If I may just for your note, you'll find examples of this behind, for example, in the supplementary bundle, tabs 13, 18, 19 and 26. There are other examples, but that just gives you a feel.
Well, could we just look at one, just
Yes,
so we've
let's
got a
go.
feel for it? So the first one was 13. And what's the relevant bit?
So if you're on,
tab 13 was the first one you said?
yes, and you go to page
87.
87, and can you see there's a number of single line paragraphs? First of which is, sorry, the second of which is, would it be possible for us to auction online via Easylive auction?
Okay, and then it's repeated. So
So
if it's a typo twice.
yes,
But on the other hand, this is apparently not a native English speaker.
no, that happens to be the first in the bundle, but I can give you other examples that are native English speakers. If you go to, for example, I think 18 would be the next one.
Yep. Yeah.
18, page 95.
So that's Gerard's.
And you can see from the telephone number that it looks as if it's based in the United Kingdom. Would it be helpful if I just...
But
Sorry.
that could be a typo.
Yes, I'm accepting that. But what I'm saying is there's not one example, there's several examples of auction houses who ought to know with whom they're dealing, getting it wrong. The next category of people, which I think is relevant for you to consider, this may be exemplified by the document behind tab 12. So this is a business that is writing to the defendants. In this case, what they're trying to do is seek work, and yet they get the name wrong. You can see that on page 85, Project Easylive, prepared for Easylive. Now again, it might be a typo, but there are several examples of businesses getting it wrong.
Again, if it's a typo, it's repeated.
Yes. And you would have thought,
I mean,
This is-
so one sees it in the subject line and the name of the attachment, and then twice on the first page of the attachment.
so the submission, I mean, obviously we don't have the people here to explain it away. It might be just they can't type. But the point being is I'm making is that if you are a business trying to seek business from somebody, it behoves you to pay a little bit of attention to get their name right. Now this is not a unique example. Another example may be found behind tab 20 on page 100. And on page 101, you can see it's halfway down, organisation, customer info, account info, your organisation, Easylive. Then there's correspondence, and if you go to the previous page, page 100, you can see it's been corrected. But that's after an intervention by the defendants. Now, of course, that might be a typo as well. But again, I would say it is relevant that a business is writing to another business seeking work and getting the name wrong. And then the third category of examples that I'd like to draw to your attention are not just from customers of the defendants, but from regular customers of the defendants. An example of this may be found at tab 30. So tab 30 of the supplementary bundle, page 122. Hello, I've been denying bidding on most of the past auctions I have tried to. I have been an Easylive auction member for almost 2 years. So this is not somebody who is a novice, somebody who's new to the defendants. There are several examples, but let me just take you to a couple more, or 3 more actually. Page 7, sorry, not page 73, tab 73, page 196. Second sentence. This is extremely worrying as I do a lot of business with Easylive at auctions. The next tab, 74, page 197. Hello, I'm a regular bidder on Easylive. And then halfway down, as a regular buyer, I know how the website works. And actually the line above that is interesting because...
Sorry, which page are you on?
I'm terribly sorry, my lord. I'm on tab 74, page 197.
So we looked at tab 73, then tab 74.
Yes, and I'm halfway down the page. It's underneath the date 7th March 2022.
Yeah.
Hello, I'm a regular bidder on Easylive. 5 lines down, I was told that this was charged according to Easylive auctions instructions. Now you could take the point there's no apostrophe there, so therefore it's a careless typist. I do not know how or why this was added to my bill. As a regular, again, space missing out, buyer, I know how the website works. Now, while there might be typos in that, this person appears to be referring to the defendants repeatedly as Easylive. And then something similar may be found behind tab 89, page 216. In line 2, he refers to Easylive. And then 3 lines up, I have used Easylive many times and spent a considerable sum. So the 3 categories there: auction houses, who in my submission should know better; prospective businesses or actual businesses who are communicating with the first defendant, who again ought to know better, or ought to at least try harder to get the name of their prospective customer or actual customer correct. And then thirdly, regular users. So this is not somebody who's come along for the first time, but somebody who's used it for many years, gets it wrong. And we say that this is, yes, it could be all typos. Every single one of these could be a typo. I have to accept that as a possibility. But in my submission, actually it points in the other direction, that these are people who do not notice the difference. So either they do not know that the correct name is Easylive, and I get some support for that from the regular users, or if they do know, sorry, I think I said that incorrectly. Either they do not know that the correct name is Easylive, my apologies for getting that wrong, and they have not noticed the difference, or if they do know that the correct name is Easylive, and when they've typed Easylife, they haven't spotted their mistake, which again we say is evidence of direct confusion.
But it could go back to the judge's point that Easylive on its own doesn't make much sense. So people, when typing, just might think, oh, is it Easylife? And just type Easylife, because that makes on its own more sense.
Well, in which case
It wouldn't necessarily be confusion with another brand mark sign.
Well, in which case that means they think the name of the defendant is Easylife. Because on your analysis, my lord, I think it is that the person who's doing the typing has thought that Easylive doesn't make sense, therefore it must be must be Easylife.
You would say that supports the existence of a likelihood of confusion
Yes.
on that hypothesis.
Yes. Now, I accept all the points that can easily be made against me. Could be typos, yes. It's unlikely to be any automatic spelling correction, because none of these words are normal words that would be called by an automatic spelling correction. That was put towards me earlier, first case. It's possible that these people are just being sloppy. But there's no real evidence of that. There's no real evidence that these people are abnormally ignorant or abnormally inattentive. These are normal people. And also what supports me in that particular point is that some of these examples come from businesses. Surely if you're a business trying to get business, you should be a bit more attentive. And also, what about the auction houses? The whole point about the auction houses, it was said that those people pay a higher degree of attention, therefore they're less likely to be confused. But they're still making the mistakes.
Are you relying on this, as judges dealing with this 117, as actual instances of actual confusion in the relevant sense? Because the judge says that's not what these are.
Well, I'm actually.
Or are you relying on it for the point you made a few moments ago, that this demonstrates there's no conceptual difference, which is a different point, isn't it?
Yes, it is. In some senses, I'm trying to cover all bases, because I say that this is actually evidence of confusion, even though it was completely dismissed as only being administrative errors because they were just simple typos. But I say that on the analysis that I just put forward, it can be advanced properly that this is actual evidence of confusion. But if you don't like that argument, if you're against me on that, I can still say this supports conceptual similarity. And also there's another point I'm going to pick up later, that this is evidence of imperfect recollection.
But on the first point, then, which is the one the judge is referring this for that purpose,
Yes.
are these instances of actual confusion. The reason he says it's not is because it's not confusion in the relevant sense, because no one would have been confused about the entity they were dealing with. So it wouldn't be, as I understand it, confusion which includes the likelihood of association with the mark.
Well, the point is that if I'm writing to the defendant and I think the defendant's name is Easylife, then I say what they have confused is they've got the name of the defendant wrong.
Yeah, but it's two different questions. One is, are they actually confused in a trademark sense? And secondly, even if not, is there a risk of confusion?
Yeah.
Because what this evidence demonstrates is the ease with which the letters can be transposed irreversibly.
Yes, and see, my lord, I heard
And-
Lance, sorry.
The second point doesn't demonstrate the first point.
Yes, exactly. So I'm trying to answer both your questions at the same time. I'm taking it in the cascade. On my highest point, I say it's direct evidence. Failing
Yeah,
that,
but that's what my lord's question
Yes.
is directed to.
Yeah.
Why?
because the way in which I've explained it, that these people clearly have misidentified the name of the defendant. Now,
But not thinking, there's no evidence they did say thinking it was the claimant.
that's correct, but in my submission that doesn't matter. But if you're against me on that, then I still say that this is indirect evidence that the two can be confused and or is evidence of imperfect recollection, i.e. they know that the defendant is called Easylive but have imperfectly remembered it as Easylife, as maybe you're working on the assumption, as my Lord Justice Coulson put it forward, that Easylive didn't seem to make sense, so they've mutated it in their own internal analysis. But all of this, now of course we don't have the advantage of cross-examining these people to work out what their inner thoughts were, but we say this all points to the existence of the likelihood of confusion. May I very briefly go back to the judgment, because in the next paragraph, paragraph 118 at page 111, he then talks about the other examples, the other 11 examples.
Of the judgment paragraph, 118.
Yes, my lord,
Yeah.
page 111.
Yeah.
He talks about 4 more examples. And unfortunately, there's actually 5 of them. But again, it's not material. It's just a typo, I think. This is in essence where it's the other way around, where instead of seeing in the defendant's disclosure the incorrect use of Easylife, what one has now is in the claimant's disclosure incorrect use of Easylive. So that's indirect evidence that it can be taken both ways around. And slightly negates my point, the point that my Lord Justice Coulson made about people trying to make sense of the word. I'm running out of time, so if I may take the next a little bit more quickly.
Well, this is ground 4.
No, sorry, I'm still
You're still in
still in this bit, but yes, ground 3. But the point being here is that with respect to the actual examples that are analysed in detail at 119, the first example, when one reads it carefully, it is actually fairly clear that the person was unsure, so therefore there's little probative value. If you look at the example under paragraph 119D, that's an example of initial confusion, but the person was then disabused of their initial mistake. Actually, what might be useful, Shall I give you the tab numbers where all these correspond to, because you find them most easily? Literally in order, so 119A, you'll find that at tab 14. Then B you'll find at tab 15. C you'll find at tab 62. D you'll find at tab 48. E you'll find at tab 54. F you'll find at 58. And G you'll find at 79.
Thank you.
And if you go So if you look at those, we still say that obviously absent cross-examination you can't be sure, but it really does seem to be, and the judge seemed to accept it, that the remaining examples could be taken of evidence of actual confusion in the strictest sense. Then turning the page to page 113 of the bundle, paragraph 121. This is where the judge comments that there's been a long period of, in essence, coexistence. And if you see the bottom, Easylive auction name has been used since 2010, some 14 years. That's true in the sense it did start its use first in 2010, but there's only really been significant use since about 2017 at the earliest, or 2019. And my support for that comes from the first instance judgment of the first case, where Sir Anthony Mann at paragraph 218 says that there was only significant use since 2019. For your reference, that may be found in the third authorities bundle behind.
How can you rely upon that judgment for a finding of fact?
Well, I'm finding, because the evidence here is that the use, it's only a collateral argument, my lord. I'm not finding upon using it as a strict finding of fact. What I'm saying is, to support my proposition, an earlier judge in the first round of the litigation between these parties found that the significant use started in 2019. I say, therefore, you can't say there's been significant use since 2010.
Right, so it's a finding as between the same parties.
Yes.
Now could you give us the reference?
My lord, yes. Authorities bundle number 3, tab 27, page 943, and it's paragraph 218 of that. And we say when you look at all these, that there's clearly some evidence of the existence of the likelihood of confusion. Now, we also say pray in our support, imperfect recollection. We say again, if you look at that evidence, depending how you look at it and depending how you finally analyse it, it could support the proposition that there is imperfect recollection. That is, if the people who are writing to the defendant know the correct name, Easylive, but have incorrectly remembered it as Easylife. There is more to the similarity between the trademark and the sign than just the commonality of the word easy. this is put forward in the judgment at paragraph 137, because that ignores the fact that 7 out of the 8 letters are identical and in the identical place. And depending on how you want to look at it, either people don't notice that, or they do associate the those two marks. And if you go to the supplementary bundle behind tab 95, you find an interesting example. Where a person is complaining about some potentially fraudulent transactions and has listed them out.
Sorry, page.
Page 225, my apologies, my lord.
My fault.
Sorry, tab 95, page 225.
Forgive my ignorance, where is Ben Bakula? Is that Northern Ireland? Or is it Wales?
I do not know the answer to that question, my lord. I'm sorry. I can find out, but
Doesn't matter.
right. Those behind me are saying Scotland.
Oh, right, okay. So I completely wrong all round, thank you.
Well, it may or may not be because of the Gaelic between Northern Ireland and parts of Scotland on the west coast. A lot of the names are quite similar if you look at bits. But I can't give you
Anyway,
an
the
answer.
point,
Yeah,
my relevant point.
Yeah, my point, my lord, is that this person's listed a number of what they think might be fraudulent transactions. You can see that in the last line before the list. And the list goes down Easylive, 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 Easylive. And then something else, and then Easylive. So that seems to be unlikely to be a typo. But what this person seems to have done is associated the occurrence of Easylive on his credit card statement with those that relate to Easylife. Now, I can't...
Sorry, your proposition that he's intending to distinguish between the two.
No, my proposition is that in this case he's associated the two together, thinking that they are related and that transactions that relate to Easylive can be addressed by the people he's writing to at Easylife.
That supposes he's dealt with both. Is there any evidence of that?
No, all you can say is I've purchased items from Easylife. But he must have dealt with both because this is entries on his credit card statement.
The alternative hypothesis is that when he types Easylive one time, that is a typo. And he's intending to type Easylife on that occasion as on the other occasion.
Well, that's a possibility, my lord. But what I'm saying is that he's trying to type this out quite carefully. He's put down the dates, the amounts. You would have thought he's paying some attention because he's trying to draw the correspondent's attention to an alleged fraudulent transaction.
Well, I can understand the submission that it's evidence that even a person taking care can inadvertently type the wrong name. And in that sense, it's evidence of a potential for confusion, but
That's as far as I'd like to take it, my lord.
okay.
Anything else on ground 3?
It's the interdependency point, my lord, but you've already heard me address you on that already, in the sense that he doesn't seem to take into full account the fact that, having found that there's identicality or high similarity between the relevant services, and that there is similarity with respect to the visual and oral conflict between the marks, and also taking into account enhanced distinctiveness, imperfect recollection, that all of these weigh together, and, so to speak, if there is any weakness in the argument that there's a conceptual similarity, then that can be swamped by these other points because it's an overall balancing thing. He seems to allow the alleged conceptual dissimilarity to trump everything else. So we say, in summary, all the points, all the factors point in one direction, namely the existence of the likelihood of confusion. So therefore the judgment was unsupportable. My lords, for the last ground, ground 4, this basically just flows from everything else.
Yeah.
If there is an existence of likelihood of confusion, then the defendant's 957 is bad, mark is bad. And that's accepted. And for your note, that's paragraph 84, the respondent's skeleton, tab 8, page 68. But that was accepted below as well, and there's nothing radical about that. My lords, are there any other questions that I can try and field?
I don't think so. Thank you very much. We'll give the transcribers their break now.
Fantastic. Thank you very much.
I was saying.
Well, I saw my hot.
Yeah.
Yeah, I know. And it's significantly high, so the report in the top atmosphere.
Maybe they've got
Fans.
secret air movement.
Then they really wouldn't want to hear.
Yeah.
In the old, they used to get diets, so it was really quite warm. It's freezing. I mean, freezing. I've been there where trademark has not taken off her gloves, hat, scarf, and behind this dais, which is really quite big, you can see that the hearing officer had a little electric fire. Just toasted his toes.
Cozy.
Yeah. So how are your 3 screens holding up?
Yeah, good. Yeah,
It's quite good.
they haven't fallen off yet. Yeah, it works
That's
really well.
good.
Do you buy? Is that specifically designed for that model?
No, size screen. Actually, I mean, it's got a range, so it works.
That's what I was wondering, because mine I think is slightly different in size.
Yeah, so I could have bought bigger for a bigger screen.
These are kind of similar to these.
Yeah.
But it packs up quite small.
Do you know, it doesn't pack up very small. It's not very light.
Oh right.
But I mean, it's portable. It's like an old-fashioned laptop, you know.
No, you say old-fashioned. The first laptop I had was 25 kilos.
Good grief.
It was called portable because you could lift it.
Yeah.
That's as heavy as my dog.
No, I remember carrying it home. I remember carrying it home. And it was one of those green screens.
Cathode ray tube.
Yeah, it was
Right.
ages. It was ages.
Yeah.
You all forget I'm ancient.
Yeah.
First computing I did was with punch cards. You don't even know what punch cards are, do you? No. You do, don't you?
I know, but you know, they were.
This is where you have a card, like an airport ticket card,
Mhm.
and you have to punch the hexadecimal code, literally punch out a little flap in each line. So the computer can then optically read the hexadecimal code.
How time consuming.
Yeah, the pro. That's one of the reasons my computer programs are a lot shorter.
Yeah. It's still being live streamed. Everyone's going to have the benefit of it.
Oh, well,
Yeah.
hopefully all the stuff I said was much fun.
Court riser period.
Yes. Mr. Akins.
So, as my learned friend has indicated, in this speech I will address the court on the appeal, the respondents' notice points, all of them that are outstanding, and the cross appeal. The way I intend to structure my submissions is to first give a summary of the case and why the judge was right to dismiss the infringement claim. Then I propose to address the appeal, which only concerns infringement. Third, I'll address the 2 outstanding respondents' notice points, which also concern infringement. And lastly, I'll address you on the cross appeal, which concerns revocation of the stylised mark. I appreciate that's not the order in which the judge dealt with things. However, the judge held no infringement, even dismissing the revocation counterclaim. So it's right that I address it on the basis that the mark remains on the register. And secondly, the cross appeal, as with the counterclaim generally, is only pursued defensively. So the respondents advance it and advance that aspect of the appeal. So they advance the cross appeal only in case the appeal is successful. So the summary of the case, that this is my learned friend, has indicated a claim for registered trademark infringement only under section 10(2)(b) of the Act, which requires a likelihood of confusion. The question for the court in this case, as in all such cases, is whether, having regard to a notional and fair use of the trademarks in relation to all of the services for which they are registered, and Secondly, the actual use of the signs in relation to the defendant's services. There is a risk that at least one of the categories of average consumer might think that the services come from the same undertaking or economically linked undertakings. So the first part of the comparison is the trademarks. My learned friend took you to the two trademarks in issue. He took your lordships briefly to the parts of the specifications of the trademarks are relied on, but not in detail. I can just take your lordships to those. So you can start with the judgment in the core bundle, tab 11, page 99. The specification for the stylized mark, the first mark alleged to be infringed, is set out in paragraph 58. And as my learned friend indicated, it's advertising services, promotion services, they were relied on. And then it's B2, they're bringing together for the benefit of others a variety of goods, enabling customers to conveniently view and purchase those goods from a general merchandise catalogue by mail order or by means of telecommunications. So that's the first of the two bringing together services. The next one is B3, bringing together for the benefit of others of a variety of goods, enabling customers to conveniently view and purchase those goods from a general merchandise internet website. So those are the specific services to compare on the side of the trademark proprietor, on the claimant side. And then for the word mark, the word Easylive, it's a different specification, and the judge didn't actually directly quote that in the judgment. So I can ask you to take the supplementary bundle, tab 7, as an actual printout from the register. Go to page 59 in the bundle. It's a rather imposing specification. Let me point to the important
Sorry,
bit.
this is the specification of
The word mark. So
Yeah.
that is the one that was the filing date for which was September 2020.
Yeah.
It's just the word Easylive. And the parts of the specification for this mark that were relied on were at the top of page 59, advertising and marketing services, not wholesale services, but they did rely on retail services, including online retailing, and then leave out retailing through the medium of broadcasting, pick it up again, retail services conducted by mail order, all connected with the sale of, and then you've got a very long list of different types of goods. So that's the relevant part of the specification of the word mark. So the judge was required to consider notional and fair use of the Easylive marks in relation to all the services in the specification relied on. But he also needed to consider the actual use to which the marks had been put. And that is because EasyGroup's case was that the marks had acquired an enhanced distinctive character through use. And the Easylive word mark, at least, had actually been used since 2000 by an erstwhile adversary, but now licensee of EasyGroup, Easylive Ltd. And Easylive, I can use that as a shorthand for Easylive Ltd in this context at least, used Easylive, the mark, in two ways. First, in relation to its retail business, and specifically one printed general merchandise retail catalogues of the sort you get that fall out of the Sunday papers, And secondly, a general merchandise retail website. In both cases, it's entirely conventional retail business. Customers find products they like, either in the catalogue or on the website. They purchase them from Easylive for a fixed price set by Easylive. And Easylive doesn't and has never done auctions of any sort. And the second way in which Easylive has used the mark Easylive is that it has also, since 2005, provided a service whereby third parties can advertise their goods and services by way of physical paper inserts in the Easylive catalogues. For example, an advert for life insurance. So next, the signs, the flip side of the comparisons, the signs alleged to infringe. My learned friend took you to those, essentially Easylive auction, which was occasionally shortened by employees and customers to Easylive. And the judge held that the respondents had used those signs in relation to 3 relevant categories of service, and sets them out in paragraph 93 of the judgment, which is in Core Bundle, tab 11, page 106. So it says those services for which the mark is registered are to be compared with the 3 categories of service that are provided by the defendants, and he sets them out in subparagraphs A to C. The core of the business is actually listed third, so in C. That is the service which provides an online platform for auction houses to broadcast their auction sales to customers, and for customers to bid for lots for sale in those auctions in real time. He calls that the Defendants Auction Broadcast Service. And you actually may not have spotted that there's a footnote 12 at the bottom of that page, where the judge explains his reasons for using auction broadcast service as opposed to the 2 descriptions that were offered by the parties: sales broadcast services and platform services. It says specifically, you see the second line, the former, so sales broadcast services, wrongly suggests that it's defendants that are making the sales, and the platform services was too broad in his view. So in relation to the auction broadcast service, you can immediately see that Easylive auction is descriptive of that core service. The other 2 categories are dependent on that core service and only provided to existing customers of that core service, although we don't dispute on this appeal that they are provided as separate categories of service. They are in subparagraph A, the catalogue service, which is the service which allows auction houses to upload their auction catalogues and auction event details onto the respondent's website, where they can be viewed by customers. And subparagraph B, the defendant's advertising service, which is the service of advertising auctions and upcoming auctions. The link to the relevant auction catalogue provided on the respondent's website and an email sent to customers.
So you say B and A are effectively subsidiary to C, that C is the principal service.
That's right.
B is allowing customers to upload the catalogues, and A is advance warning of forthcoming auctions.
That's right, yes.
Yeah.
So that is what the judge was comparing on the defendant's side. Use of the Easylive auction, Easylive signs in relation to those services. The next question is, here is the average consumer. and that's dealt with in paragraph by the judge in paragraph 30 of the judgment onwards. And there are two relevant categories. He held that there were two relevant categories, and they were not controversial in this case. The first is the general public, and they are the average consumer for the claimants bringing together and retail services, and on the respondent side, the bidders on the auctions, people who use the Easylive auction site to actually bid on auctions rather than the auction houses. And the second category of average consumer are business organisations and auction houses. So the business organisations are the average consumer for the claimant's advertising services, and the auction houses are the average consumer for those the respondent services that relate to auction houses. And the judge held, and there is no challenge on this appeal, that the level of attention will be higher for the second category than for the first. So the consequence is that confusion is less likely where the assessment concerns the services for which the second category of average consumers is the right one. The judge held that there was no likelihood of confusion having regard to the notional and fair use of the Easylive marks in relation to advertising and retail services, and on the other hand, actual use of the Easylive auction signs in relation to those three categories of service. So in other words, there was no risk that either category of average consumer might think that the services come from the same undertaking or economically linked undertakings. That was a classic multifactorial assessment which the judge was peculiarly well placed to carry out, having heard all the evidence and submissions of the parties at trial. And he had regard to Lord Justice Lewison's sea of evidence at trial. And just on the evidence, it's worth making some points about the evidence or lack thereof at trial. EasyGroup served statements from 4 witnesses, each of whom were from Easylive. Each gave evidence on the use of the Easylive marks and variants thereof. However, none of those 4 witnesses mentioned Easylive auction at all in their written or oral evidence. So it's a rather peculiar situation of none of the claimant's evidence, claimant's witnesses even mentioning the defendant in their evidence. The second point on the evidence is that the claimant did not serve evidence from any consumers, but as we've seen, it did rely on documentary evidence of what it alleges was confusion, alternatively supports a conclusion of confusion. The judge held against the respondents that their services were identical, alternatively highly similar to those in the specification for the Easylive marks. And that is something that we, the respondents, challenge by way of respondents' notice. However, even with that finding of identity or high similarity of services, the judge still held that the average consumers would not assume that a party trading, even trading in relation to identical or similar services, using another sign that featured the word easy, was the claimant or associated in some way with the claimant and or its mark. And his reasons were: easy is a normal word, widely used. But it didn't stop there. He also held that it wasn't just easy that other unconnected parties were using, but also Easylive. So the name of the Easylife's name and the word which my learned friends contend is the dominant feature of the stylised mark. Neither of those factual findings, so that the common use of easy and the common use of Easylive in a commercial context as a name, is challenged on this appeal. So the conclusion of no likelihood of confusion was therefore, in our submission, very obviously a conclusion that the judge was entitled to make on the evidence. And it is not one with which this court is justified in interfering. And if your lordships needed any further comfort in upholding that decision, you can find it in many other cases involving EasyGroup, including the decision of this court in EasyGroup and Nuclei, where it was held that there was no likelihood of confusion between easy offices and easy office when used in relation to identical services. And there are a number of other first instance decisions which support it. W3, the comparison was Easy Roommate and Easy Jet and Easy Hotel in relation to identical services. Easylive, so the litigation that resulted in the claimant acquiring the marks in this case, where the comparison was Easylive Group and Easylive, and the judgment of Mrs. Justice Bacon in Beauty Perfectionists, where the sign was Easy Cosmetic compared with Easy Jet. So that's the summary of the case on infringement. So turning to the appeal, EasyGroup says that the judge's decision on infringement was wrong on 3 grounds. And I note that now, today, my learned friend has pinned his colours to the mast in what he says is the type of confusion that he's relying on in this case, having not done so previously. So EasyGroup's case is that this is a case of direct confusion. So that in relation to all of the signs, including Easylive Auction, it's alleged that the average consumer would directly mistake those for Easylive, or the stylised Easylive mark.
It may not have been made explicit before, but if you look at the judgment, it's perfectly apparent that that's the only case he was considering. There's nothing in the judgment to suggest the judge thought that he was addressing a case of indirect confusion. Is there?
That's fair.
Okay.
It certainly wasn't put that they were advancing a case on indirect confusion. So on to ground 1. EasyGroup says the judge's finding in paragraph 86 of the judgment that the co-joined words Easylive are conceptually very different to the co-joined words Easylive is rationally insupportable. It's common ground that that's the test that is to be applied to this finding of the judge. It's also common ground that the judge was required to analyse and compare the conceptual meanings, the marks and the signs. And in paragraph, if I can pick the judgment up in paragraph 50 on page 97. This is in the context of the argument on revocation, but as part of that, as we'll come on to see, the judge was required to identify the conceptual meaning of Easylive. So that's part of the assessment of the distinctive character of the stylised mark. And you see the 2 lines up from the bottom of the page. The judge has identified the conceptual meaning of Easylive as the possibility of an easier life and a stress-free experience. There's no challenge to that finding. So then, in terms of the signs, he analyses those in paragraph 86 on page 105 of the bundle. And he finds that in the case of the Easylive auction signs, this was an auction that was easy and live. In the case of the Easylive sign, the answer was less straightforward because easy and live would both be perceived as adjectives, thus begging the question, an Easylive what? But in each case, the conceptual meaning was self-evidently different to easy life, i.e. the possibility of an easier life and a stress-free experience. In my submission, that's very clearly a rational analysis and comparison, and certainly one that is rationally supportable. EasyGroup makes 4 criticisms. First, my learned friend says, insofar as the judge was focusing on the respondent's Easylive sign, it was clearly relevant. Sorry. In response to the first criticism, so far as the judge was focusing on the respondent's Easylive sign, it was clearly relevant that Easylife stands by itself, but Easylive does not. That can and does, in my submission, affect the respective conceptual meanings.
Sorry, I'm not quite sure how I understand that. So let's take the first sign that's in issue, which is the 2 words Easylive.
Yes.
You might well pronounce it as Mr. Eden pointed out, Easylive. So what do you say is the conceptual difference between easy life and easy live?
Well, the judge has found that the average consumer would perceive the defendant sign as easy life, because easy live is not an adjective; it's a verb. He's saying they would perceive it as an adjective. Must mean easy live.
But why? Why can't it be a verb?
Well, certainly if one takes into account the context, and that's one of the criticisms. I accept that that's one of the criticisms that is made of the judge, which is there's the second criticism. And just to address that, we say the judge was right to consider the context because things have to be considered from the perspective of the average consumer. So when you're thinking of how the average consumer will perceive this sign, the judge has come to the conclusion that they would perceive live as an adjective, so live rather than live.
Sorry, we're here at the level of comparison of the mark and the sign.
Yes.
And of course, I take your point that when we come on to consider likelihood of confusion, we then have to consider it in context. But how can the concept conveyed by the words be dependent on the concept, on the context?
Because it's being perceived, because it's being assessed according to the perception of the average consumer, even at this stage.
So Mr. Edinburgh says that's contrary to equivalenza.
Well, I don't accept that, and I say that's supported by what Mrs. Justice Joanna Smith said in Shine TV. Taken to that. So that's at the Authorities Bundle 3, tab 24, page 764. paragraph 33, little 2, where this issue is addressed. So, and the judge says, second, there was one legal issue in which, at least initially, there appeared to be disagreement between the parties. In his skeleton argument for SKA, Mr. Muirwood appeared to suggest that when accessing the conceptual similarity of two marks, it's legitimate to have regard to the goods to which the marks relate. Chantriel pointed out that was contrary to equivalenza, and a further decision of Mr. Philip Johnson. In his oral submissions, Mr. Muirwood provided a rather more nuanced approach, accepting that he'd gone too far, pointing out that whereas here the marks which are being compared are concerned with the same goods, so that the average consumer is the same, it's impossible to ignore that fact in considering the conceptual similarity of the marks, in particular the perception of the average consumer as to their meaning.
That seems to be about the identification of the average consumer.
Well, it's about the perception of conceptual similarity.
She's not saying that you take the relevant goods or services into account.
That's right, and I'm not going that far. But context is still relevant in the sense that we're looking at things from the perception of the average consumer in this case.
But the error that the judge is said to have made is that he did take the services into account. So you don't defend that.
To the extent that, well, that the average consumer is an average consumer of the services. And there is no basis on which the judge could find that the average consumer would perceive the defendant's sign as Easylive.
Why not? If they're reading it, how do they know how it's pronounced? Is there some manual to pronunciation out there?
Because it's a very unusual, in my submission, way to read it.
I'm struggling to understand. So we hypothesize an average consumer, and we're talking here about particularly the class constitution of the general public. So they encounter the two words, easy, L-I-V-E, and you say that they, without hesitation, understand that that means easy live and not easy live. How?
Well, the judge has found that that's how the average consumer would perceive that sign.
The reason why he's come to that is by making the error of taking the services into account. And that's the argument against you. And you accept that it would be an error to take the services into account.
I do, yes.
And your answer is context, but I'm struggling to understand what it is about the context that you're relying upon.
The context is that this is an average consumer of the defendant's services that we're looking at here. Even if I'm wrong about that, then it certainly doesn't apply. The point certainly doesn't apply to Easylive auction. The sign Easylive.
Of course not. What about Easylive services or Easylive services?
Easylive services is obviously neutral, so that doesn't indicate what they're being used in relation to.
Right.
So I take that point. And the other point to make is that even if the judge was wrong to take it into account at that stage, he was obviously entitled to take into account the services at the assessment of the likelihood of confusion stage. So whilst equivalenza is clear that at the stage of comparing conceptual meanings, you shouldn't take the goods or services into account. You obviously should take them into account when it comes to assessing the likelihood of confusion. So in my submission, if there is an error here in paragraph 86, it's not a material error. He just jumps the gun a little bit. when you're comparing infringement by use of Easylive in relation to the defendant services, you obviously take those services into account. The other point to make in response to my learned friend's submissions is that it's telling that EasyGroup has not set out what it contends is the conceptual meaning of any of the respondent signs, including Easylive. So we see that's a clear distinction between this case, if one was needed, between this case and the TVIS case, where it was squarely put that the conceptual meaning was the same, perpetual and vetual was the same. And the friend hasn't compared the judge's conceptual analysis of Easylive as the possibility of an easier life and stress-free experience with the conceptual meaning of the defendant's signs.
Well, that's because he says the concept is essentially the same. I mean, of course, if he was arguing they were different, then there would be an onus on him to say what the difference was. That was the point made in that case. And so it's not for him to say what the difference is, it's for you to say.
Right. In relation to Easylive, I say I support what the judge has said.
Yeah.
In terms of the difference. In relation to Easylive, I say I don't know what that means. Certainly doesn't have the clear and obvious meaning that Easylive has. The fourth point that EasyGroup make under this ground is they say the judge gave undue weight to conceptual dissimilarity in its overall assessment of the likelihood of confusion and downplayed the significance of the visual and oral similarities that he'd identified. So this is a point about likelihood of confusion and the weight to be attributed to factors. It's not a point of law. And so we say the judge should be given, should be deferred to on this if it's a point about weight. They don't say that he was not entitled to take the conceptual meanings into account at all. That would be contrary to authority. So the judge was entitled to take them into account along with the visual and oral similarities, as he did.
Can I just be clear as to how far you go here? Because I was just refreshing my memory of what you said in paragraph 61 of your skeleton argument, where you accept that the judge didn't find that this was a case of conceptual counteraction.
Yes.
So you didn't eat it.
Yes.
But then there's a sort of a slight equivocation where you say arguably the test is met.
Well,
but you don't have a respondent's notice on that point.
That's right. My learned friend stopped short of saying that the judge held that there was conceptual counteraction.
So to that extent, there's common ground.
Exactly, yes.
So we leave it.
Yes.
Very good. Thank you.
But to be clear, it wasn't relied on below by the defendant's conceptual counteraction.
Okay.
And we say the judge doesn't rely on it either, as a result.
Edinburgh put it this morning was that the conceptual difference trumps everything else. He says that's how the judge approached it. Do you accept that characterisation?
No, I don't know that. He doesn't trump everything else. In particular, because of the findings that, in relation to the word easy and in relation to the use of Easylive as well. So he's found that both the use of easy was very common in commercial undertakings and indeed the use of Easylive.
Where is that? The latter of those two.
Yes. Bear with me 1 second. So it's actually in 56. Yes. So if you see the sentence 4 lines down, case of the Easylive stylized word, mark, that word is used in combination with another simple descriptive word, live, combination which, as Mr. Hansel was the defendant's solicitor, gave a statement, used in normal speech and which has also been used by third parties as a ground or part of the plan. The average consumer would be aware of this. So ground 2 is enhanced distinctive character. The judge held that both marks had an enhanced distinctive character, and there is no challenge to those parts of his decision. It is also common ground as a matter of law that there is a greater likelihood of confusion where the earlier mark has a highly distinctive character, either per se or because of the use that is made of it. That's part of the list of factors that's commonly cited. But, as was suggested in argument earlier, can't take that too far. Doesn't mean that in every case where it is established that the earlier mark has a highly distinctive character, either per se or because of the use that is made of it, there's going to be a likelihood of confusion between that and whichever sign that you're comparing. EasyGroup says the judge failed to apply the principle. We say that is wrong and that they are subjecting the text of the judgment to too harsh an analysis. I can pick it up in paragraph 81 on page 104. This is where the judge is citing the relevant principles.
Sorry, give me the paragraph reference again.
Paragraph 81 little h.
80.
Yeah.
It's the list of principles from the Liverpool gin case, and H is the principle that I've just enunciated, that is relied on. So he cited the relevant principle. In 107 on page 109, the judge recorded the EasyGroup's reliance on the principle. See that from the first sentence. And then he makes some findings or records the evidence in relation to use of the mark in the rest of that paragraph. And over the page is the relevant paragraph for the purposes of this ground, and the paragraph that EasyGroup says contains the error. They focus on the second sentence.
Paragraph.
Sorry, 108.
Yeah.
Page 110.
Yeah.
So he says, I accept that this established an enhanced distinctive character for the Easylive stylized mark. However, I agree with the point made by Mr. Akins in opening that this does not mean that the average consumer was any more likely to be confused. I also draw your attention to the last paragraph. I do not accept that the enhanced distinctive character in this case would have led to any real likelihood of confusion, given the descriptive and common nature of the word easy and the very clear conceptual differences between these stylized mark, the defendant size, to which I've referred above. So what I say is going on in this paragraph, that the judge is not disputing the principle or failing to apply it. All he's saying is that it just doesn't get EasyGroup home in this case. As my Lord Justice Zacaroli said earlier in argument, this is a question of degree. The judge has taken enhanced distinctive character into account, but it does not shift the dial.
Oddly, the test is there exists a likelihood of confusion. That's the statutory test.
Yes.
If I took subparagraph 8 to its logical conclusion, if there's a greater likelihood, there's a likelihood already, so you've passed the test, but that cannot be how it's read.
Yes, I agree. But in my submission, it's it might result in enhanced distinctive character might result in a finding of a likelihood of confusion in circumstances where without the enhanced distinctive character you wouldn't get there.
And it could, in the right case, it could be the tipping point.
The tipping point, yes, my lord. but it is not. And the judge is finding here that it is not in this case. He's taken it into account. He's held it doesn't get him there. So the second sentence might have been more felicitously expressed. I accept that, but the whole paragraph needs to be read together. And that is what I say is going on in this paragraph. It's taking into account that it doesn't tip the balance. And so there's no basis to interfere with his decision in this paragraph. Well, I'm going to come back to enhance distinctive character in the context of the respondent's notice, but I'm going to do that after I've finished with the appeal on ground 3.
Right, so your next port of call is ground 3.
Yes.
So we'll deal with that at 2 o'clock. Thank you very much.